Lawyers of Reddit. What's your best most baddest I rest my case moment? Guy in a divorce case transferred money to the Equity Preservation Corporation. I looked at the corporate filing. There were only 2 shareholders. Knowing who they were, I asked on cross-examination. He denied knowing them. I then asked about them by name. He admitted they were his parents. Was the Bank of Mom and Dad the old name for this corporation? When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said to shake counsel. I still had to go forward, but we got off on the right foot and I ended up with an A. Genius. Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried multiple times to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. Oh, that had to be excruciating for everyone, especially the court reporter. Corporate lawyer. So I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating. And I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, "Well, of course it's fine when we ask for it." I do mostly solicitor work, so if I'm doing my job right I don't get a whole lot of these type of moments. That being said, I had a long-time client who was being sued and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out or he can find himself another job. He takes the latter option. But he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid. 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Classic Kevin. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what. He said the lawyer is never the one who goes to jail, that he isn't going to jail for me. And if I lie, I'm on my own." Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." I had a trial against a guy who was self-representing and he was constantly asking my client about conversations she had with me. First of all, no, I'm not coaching her to lie. And second of all, there's a thing called privilege, which means the things we discuss are not compellable. It was an exhausting trial. Needless to say, he was ordered to pay about $1 million more than he actually owed. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, dude admits that he never reviewed any documents to make sure his allegations were true. Never reviewed his complaint before filing it to make sure the allegations in it were true. And had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money at arbitration. He tries to flip his story and starts giving testimony that is the exact opposite of his dep. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. 5 miles per hour over is probably just a fine and a few points. 17 over is possibly reckless driving depending on the officer's discretion. I'd take that. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said yes. In England, we don't say I rest my case. Instead I looked up at the bench, said no further questions, and sat down. It might not seem bad, but I got the defendant to admit the offense with one question. That never happens. IP lawyer deep in a set of terms and conditions on a website. Our client's details, name and contact details, were listed. So it is very evident that they just copy pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick Ctrl+F for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Welcome to the world of law where we spend millions on technology but people don't know how to Ctrl+F or use a simple spreadsheet. My wife and not me. And it was during sentencing. MR. Defendant, local gang boss. You stated you are not and have never been in a gang. That's correct. Do you have any tattoos? Yeah. I have a tiger on my calf and one on my chest that says GD for life. What does GD stand for? Gangster Disciples. But, I mean, no further questions. Your Honor. Good deeds for life. That would have been an easy out TBH. I'm relatively junior so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom. But it is impossible for you to be successful without expert evidence. Our matter was then called and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Complaining witness accused my client of harassment stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating. But whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. This is MR. So and so. Right? Yes. In this photo. He's on the bed? Yes. The bed is yours? Yes. The bed is in your bedroom? Yes. You took this photo of him? Yes. He's smiling in the photo? Yes. And in this photo? He's wearing your brassiere? Yes. No further questions, Your Honor. I was in traffic court one time and saw a lawyer own a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and wind so strong that the defendant could only open his window 3 inches. And that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car, through a 3-inch crack in the window, on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log, to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice spot of tea and some scones. Terrible people had stolen all of this little old lady's money. They said it was a gift, but their only evidence was a document in the BD person's handwriting that was allegedly dictated. It said September 2012. No day, just the month. Clearly the rogue had forged that when she found out about the lawsuit, and, not remembering when she had stolen it, she hoped if she could guess within the month no one could challenge her. So I'm questioning her about it. Exhibit B is the little old lady's bank record. Now that withdrawal at the bottom. Is that the alleged gift? Yes. Can you read the date of that transaction for me? The 25th of August, 2012. Thank you. My client and his wife were woken up one night because people were trying to break into his house. He fired 2 warning shots as his wife called 911. The neighbor also called 911. When the police got the neighbor's call that there were shots fired, the police sergeant radioed the other officers and said he's going to jail tonight, referring to my client. So obviously, even with signs of someone trying to break in and his wife calling 911 for help, the officers arrest my client for endangering his wife by shooting inside the house, nowhere near her. It gets to jury trial and I start to go off on the police sergeant about why she would say that before an investigation and before she even had any idea what happened. The sergeant had no idea how to respond and literally just sat there staring at me for a solid 2 minutes before saying anything. Even the bailiffs were audibly laughing. So I'm fighting a DWI case and the cop is a lying liar who is telling big lies about what signs he saw on the field sobriety test that my client was allegedly intoxicated. The state had not moved expeditiously enough to have a copy of all of the evidence in the case. So we got him up on the stand talking all about how my clients looked on the horizontal gaze nystagmus sight test, then buried him with his own body camera footage which he thought had been destroyed. It wasn't. The judge, the newly elected Democrat in Texas, made findings on the record that the police officer had intentionally lied and misrepresented the truth. The state still tried to fight the case, but it came out the right way. I have one about a lawsuit against the owner of Mexican restaurant for not paying his employees and keeping the waiters tips. He was just a terrible all-around guy. He created these fake handwritten schedules and payroll records going back years to try and prove that his employees didn't work but a few hours each week and were paid for what they did work. It was difficult to prove they were fakes, but we managed to trap him during his deposition. I made the guy go through random bits of his work schedule and asked him to confirm they were correct. We did a random week in February, March, April. Then we got to May. So here in early May, you had 2 servers working every night. 1 hostess, 1 bartender, and 2 cooks. Yes. And that didn't fluctuate. You didn't have a need for extra staff on, say, weekend nights? No. It was very steady no matter the day. What about on this Wednesday? How much staff did you need? Just the 2 servers, my hostess, the bartender and 2 cooks. The same as every other night. And if you would indulge me, what date are we looking at? The 5th of May. Okay. So it's your testimony under oath that you had the same staffing needs on May the 5th as you did on the 4th of May and the 6th of May. Yeah? So you are comfortable telling the judge you didn't do extra business on the 5th of May? Yeah? Or the 17th of June or whatever date you pick? It was always steady. You have no problem walking into court and telling the judge and the jury, under oath, that your Mexican restaurant didn't need any extra help on the 5th of May. That these schedules and payroll records you've produced are 100% accurate. For Cinco de Mayo? You are totally comfortable with doing that? Yeah? The case settled within a week.